Mr Chairman. Mr Chairman.
Jacinda Ardern.
Thank you, Mr Chair. I want to come back to some of the review processes that are being established around the public safety orders, particularly under Part 1, Clause 14. And I do think the review process is important, given, as has already been stipulated, this is a civil regime which is a departure from the principles, well-established principles within our justice system. And those were the points that were raised by the Greens. But one question I did wish to ask of the Minister, and whilst I agree with the principle of what's been done here, with some significant caveats, I'd be interested if the Minister wanted to explore the difference between the use of preventive detention versus the orders that we're looking at today. Preventive detention is internationally used in order to ensure that an offender who has a potential risk at the time of sentencing of repeating their offence if they're not given a indeterminate sentence. So a judgment is made at the time by the judge that the seriousness of the offending and the nature of the offender is such that a indeterminate sentence needs to be used. But the threshold in New Zealand for that, as I understand it, is offences that may be no less than 5 years. The standard in these sets of orders is 7 years, so a higher threshold test. So actually those who might be up for consideration of preventative detention could end up being the exact same offenders who end up having public safety orders. But the punishment is somewhat less for the public safety order, given the additional freedoms that are granted, given it's a civil regime. And yet there are, as I understand, currently, as of 30 June 2010, 719 prisoners serving indeterminate sentences. Compare that to some parts of Australia, states in Australia, Victoria's 54, Queensland 350. We use preventive detention, comparatively, what would seem at a relatively high rate. I'd be interested if there's any international comparisons. So 719 uses of preventive detention has a slightly lower threshold, probably targeting the same group, has a lower set of tests probably as well, because we're requiring a range of tests by psychologists, health assessment, an ongoing monitoring regime by courts to ensure that on a yearly basis that protection order, so that public order should still apply. Preventive detention, a parole board can say we don't want to see you for 5 years. Which is quite different to this regime. So interesting that we draw the line here to say that a public safety order would be a breach, but a preventive detention order, which is granted at a time when there hasn't been, say, a sentencing period to assess whether or not indeed a prisoner is an ongoing risk, is somehow a greater breach. Now, I'm sure that there are all sorts of reasons around our justice system which would determine why that is, the point of sentencing and so on. But when you actually just break it down, it's an interesting question to say which could you consider to be a greater a breach of someone's human rights. The decision at the beginning for a sentence that would usually perhaps could even only attract 5 years to say, well, actually, we're not going to tell you whether or not you're ever going to be released. We consider you that much of a risk, versus an individual who, after serving 7 years, is determined under a very high threshold to still be a risk, and we determined that we would do a yearly ongoing monitoring at a lesser enforcement level, so not within a prison system, but within a civil regime. So I understand why they're obviously two different bars, but if you break it down like that, one might consider the issue somewhat differently. So going back to the review process that's set out in Clause 14, because it is an annual review, my question is that at that annual review, and the Minister might like to clarify this, my apologies if it's contained in the law, will a full assessment happen each and every time within that review process that's set out in Clause 14? Because it didn't seem quite clear to me whether it would. because the initial assessment as to whether or not someone should have a public safety protection order applied to them is that they will have a report by a health assessor, at least two, separately prepared. They have to, Mr. Chair.
John O'Naylor.
I move that the question now be put.
The question is that the question now be put. Those who are of that opinion will say aye. Aye. Contrary opinion will say no. The ayes have it. The question now is that the...
No, and a party vote called for.
Oh, sorry, I didn't hear the party vote called for. I accept the member's word. A party vote will be held, and the clerk will conduct a party vote. Can I just remind members to be a bit louder for that sort of thing?
New Zealand National.
60 in favour.
New Zealand Labour.
32 votes in favour.
Green Party.
14 opposed.
New Zealand First.
11 votes in favour.
Maori Party.
2 votes in favour.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
Right. The question is that the motion be now put. The ayes are 96, the noes are 25. The ayes have it. We now move to the substantive questions. I will first move to the Minister's amendment as set out on SOP number 20. The question is that the amendment be agreed to. Those who are of that opinion will say aye. To the contrary, no. The ayes have it. Was it a party vote? Is he calling for it? Party vote has been called for. The clerk will conduct a party vote on the amendment.
New Zealand National.
60 in favour.
New Zealand Labour.
32 votes in favour.
Green Party.
14 opposed.
New Zealand First.
11 votes in favour.
Maori Party.
2 votes in favour.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
The question is that the Minister's amendment to Part 1 SOP number 20 be agreed to. The ayes are 107, the noes are 14. We now come to the substantive question that Part 1 as amended stand part. Those who are of that opinion will say aye. To the contrary opinion will say no. The ayes have it. A party vote's been called for. The clerk will conduct a party vote.
New Zealand National.
60 in favour.
New Zealand Labour.
32 votes in favour.
Green Party.
14 opposed.
New Zealand First.
11 in favour.
Maori Party.
2 votes in favour.
ACT New Zealand.
1 vote in favour.
United Future.
1 vote in favour.
The question is, Part 1 amended stand part. The ayes are 107, the noes are 14. Part 1 will stand part. We now move to Part 2, which is debate on clauses 90A to 125 on the schedule and on the Minister's typescript amendment to the schedule. Jacinda Ardern.
Thank you, Mr. Chair.